What's good, YouTube? This is RPU here, and I'm back again with another video. Follow me on Twitter at RPUReloaded. Guys, I got some breaking news, man. The SEC is out here working overtime. The SEC has just filed a new motion in the Ripple case. A response to their response. It's crazy. They call it a sir reply. We're going to talk about it. This is from James K. Fallon. This is from today at 10:16 this morning. It says, XRP community, SEC Gov versus Ripple. XRP. SEC files request to file sir reply regarding motion to strike, citing SEC versus LBRY decision in which New Hampshire federal judge granted judgment on the pleadings on an unrelated selective enforcement defense. And he also posted, this is the LBRY decision on the motion for judgment on the pleadings on the selective enforcement defense raised by LBRY in New Hampshire. Megan says, at Johnny Deaton, can you please explain this? It just seems like another delay tactic. John E. Deaton says this isn't a big deal. The SEC wants to write another paragraph or two based on this LBRY case decision that came out February 7th. Even if Judge Torres denies the request, the SEC brought the case to her attention by this letter. This LBRY decision has little to zero impact. Let's sure hope so. Patty XRP says, the fuck is a sir reply? LOL. That's crazy. XRP Green Ranger says anything to delay. Ain't that the truth? That shit's crazy. Wrath of Kahneman says, wow, they seem adamant about getting this new precedent in, as if it would make a case they failed to establish so far. Yeah, it's like they're fighting two cases at one time. So they're fighting the LBRY case, and they just got a decision in that case, and they're citing the decision in that case to combat against Ripple. It's crazy. The SEC is out here working overtime, y'all. This is the response. You can get it on Dropbox. The reply to the reply. It says, Dear Judge Torres, Plaintiffs' Securities and Exchange Commission respectfully requests the court's permission to file the attached 3-page sir reply to Defendant Ripple Labs Inc.'s sir reply in opposition to the SEC's motion to strike Ripple's fourth affirmative defense sir reply. Courts have discretion to and frequently consider sir replies when there is good cause to do so. Good cause includes need to consider full evidentiary and legal record. Here, the court should exercise its discretion to consider the SEC's proposed sir reply so that the SEC can 1. Present the court highly relevant recent authority that directly refutes the arguments Ripple makes in its sir reply, and 2. Responds to arguments Ripple makes for the first time in its sir reply. Specifically, Ripple's sir reply argues the court cannot consider the SEC's public enforcement actions in the digital asset space filed before this lawsuit. On February 7th, 2022, a New Hampshire district court granted the SEC's motion for judgment on the pleadings and struck an affirmative defense similar to Ripple's in a case solely alleging unregistered offers and sales of digital assets, SEC versus LBRY, and they cited the case. This is recent. While styled as a quote-unquote selective enforcement defense, the LBRY affirmative defense alleged the SEC quote-unquote treated LBRY differently from other similar blockchain companies with no rational basis for the difference in treatment. In striking the defense, the court observed the SEC has brought at least 42 failure to register claims against other digital currency creators, with at least 19 of those actions asserting registration violations without accompanying allegations of fraud. The court concluded that LBRY had not presented a valid reason to disregard those other enforcement actions and held LBRY's admission that the SEC had been pursuing enforcement actions against multiple other digital currency creators dooms its selective enforcement defense. LBRY thus refutes Ripple's reply contention that the court cannot consider the SEC's prior digital asset cases. LBRY likewise dispels Ripple's argument that the SEC's history of digital asset enforcement action does not justify Ripple's fair notice defense at the pleading stage. But Ripple had been going to the SEC though. That's the thing though. Ripple had been going to the SEC and talking to the SEC on a weekly basis. So throughout those entire 8 years, like you're saying that the SEC couldn't give some type of fair notice, and they're saying that, oh, because we gave notice to these other companies that Ripple should have taken notice of those enforcement notices. But Ripple was working with the SEC, talking to the SEC, going to them on a weekly basis. This is what David Schwartz was saying. I don't get it. Beyond providing support for the SEC's request to take judicial notice of its prior enforcement cases, LBRY refutes Ripple's reply argument that its fair notice defense should not be stricken because this case does not involve fraud allegations or an initial coin offering. LBRY rejected a similar defense at the pleading stage, even though that case, like Ripple's, did not involve an ICO and only contained allegations of unregistered offers and sales. The SEC's proposed Sur reply elaborates on the above discussion of LBRY and contains additional authority that responds to arguments Ripple raises for the first time in its Sur reply. Accordingly, good cause exists to grant this motion to allow the SEC's proposed Sur reply, which is attached hereto as Exhibit 1. Respectfully submitted, Benjamin Hanur. And a carbon copy was sent out to counsel for all defendants. So, this is the Sur reply. The judge is most likely going to grant this, because, like I've been hearing, is that people want to keep this case airtight. So when this case comes up for appeal, they can't say that they weren't able to pursue their case to the fullest, So this motion, this motion being filed could potentially push the case back again. I don't know. But John Deaton says it's not really a big deal. He's citing this case, but the judge is still going to rule. I believe on the 24th. Today's the 22nd. We got 2 days. We're 2 days away. I mean, the judge could still strike that and tell the SEC to turn over the emails. I went back and looked at the back and forthness of this case. James K. Fallon has he's been covering the whole thing. I'm gonna show you guys. Let me see. So the SEC, Ripple filed a motion to compel the SEC to turn over the notes, right? The SEC requests an extension until February 17th, and then filed the motion for reconsideration of DPP. The 17th gets ready to come around. The SEC files another motion to ask for another extension for 7 more days until the 24th of February, which is 2 days away, right? And now the SEC has filed a Sur reply regarding the motion to strike, citing this SEC versus LBRY case that's going on. And that's where we at right now. I mean, the judge can still strike all of that down and force the SEC to turn over the notes, which they should, because we've already wasted so much time. They've already flip-flopped so many times and said that the Hammond speech was his personal opinion, then it was law, then they come out and say they didn't give clarity to Ether and Bitcoin, and then they say that the speech is law. Which one is it? I think that the judge should just force them to turn the emails over because they can't even get their facts straight. Anything to delay, just like XRP Green Ranger said. DPen80 says, I'm not even reading this. The SEC just looks desperate at this point. I think pissing in the wind sums them up right now. Daz says, anybody else feels this is more personal than legal? Yeah, it feels like Gary Gensler's got some type of vendetta or something. Crypto Boom says the SEC wants to double dog dare the judge. That's crazy. Stoic Fulcrum says, if the LBR case is ongoing and the 2/7/2022 decision in favor of the SEC should not be allowed until the LBRY case is over and has exhausted appeals. Only then would a case note make sense. I thought that too. I thought you had to cite cases that, were over. But the SEC is desperate to get any type of ruling, case citing that would help them in their favor. So they're going to use this, this latest ruling. I would too, but I mean, the judge still has the power to say, no, you've already wasted enough time, turn over the emails. So, there was one more thing I wanted to show you. I think I have it retweeted on my page. Tim Howard says, funny how they only request these new motions just before the judge will rule. More delay, nothing more, and it will be granted. It most likely probably will, because you want to give the SEC the chance to exhaust all their resources. So when this case is over and it comes up for appeal, then the appeal courts will just rule with the lower courts. So yeah, this is the last tweet that I want to show you. This is from Fred Rispoli. He says, these are my humble thoughts on this below. FYI, LBRY filed a fair notice defense that SEC never moved to strike. This is a completely different defense that I don't think Ripple even pled. He says, these are my thoughts on the request for surreal reply by SEC. First, this is getting even more beyond ridiculous. I've never seen this many posts pleading sirs ever. It's crazy. Second, Judge Torres will probably allow it, but that will allow Ripple to respond. So my previous estimate would be decided likely by March 11th is pushed back a minimum of 2 to 3 weeks. April 1st. If granted. Damn, we about to get pushed back a whole nother month. Exceedingly clear. The SEC's only plan is to delay. Can the judge not see that? Everybody can see that. Third, remember your jurisdictions. LBRY cases in New Hampshire, which is in First Circuit. SEC versus Ripple cases in NY, which is the Second Circuit. This is an out-of-circuit sister district court that Judge Torres is even less obligated to consider than a fellow district in the same circuit. Fourth, the judge in LBRY was placed on senior status just last year. He has been on the bench a while, and his opinion was incredibly short and very deferential to SEC. Also, as an aside, wouldn't you know it, LBRY is being represented by Perkins Coie. Oh, that's crazy. That's crazy. The same Perkins Coie that told Ripple in 2012 that there was not a security. The same Perkins and Coie that helped Hinman with the speech on Ethereum. Once again, Perkins and Coie is at the center of this case. This is crazy. It's crazy, man. We're going in circles here, and it's all leading back to the same person. Fred Rispoli says, fifth, getting to actual case law. There is a big difference between quote-unquote selective enforcement defense and quote-unquote fair notice defense. This is first thing Ripple will argue. In fact, LBRY did plead a fair notice defense and SDC did not move to strike. Next. The facts of what LBRY did compared to Ripple are significantly different. And even in their selective enforcement defense, the judge states LBRY did not do a good job stating why SEC's other enforcement actions can be discounted. Again, I haven't read the pleadings. But LBRY either didn't do a good job or the judge glossed over it because he already predetermined the result. By contrast, Ripple has detailed why the SEC's previous enforcements are inapplicable. More importantly, to repeat, LBRY filed a fair notice defense that the SEC chose not to move to dismiss. Very peculiar, almost like it is afraid to. Ultimately, selective enforcement is a very tough defense to win. Lastly, from a timing perspective, this motion was decided in half the time of Ripple's fair notice defense motion. Extremely odd. Tat says, thank you for that interview, for that overview. XRP 589 XRP says, judge, without even reading the full details, request granted. That's crazy. That's crazy. You didn't even have to read it. Hey, that's the judge's discretion. Hey, they could do that. But that's the latest on the case. The SEC has filed additional evidence to try to support their argument. But we're going to see what's going to happen in the next 2 days. They're talking about the case could be pushed back another month. He said October 1st, man. That's crazy. Well, remember the Bearable Bull poster? The sun was shining in April. We're going to see, man. Let me know what you think about all this. This is RPU, and I'll see you in the next video. Peace.